Okay, so let's talk about mediation. Mediation is a meeting, so to speak, when the parties come together and attempt to potentially settle the case. It is an opportunity for the parties to meet with a third party neutral, which is essentially a person who has no interest in the case, who will go between the parties to see if the entire case may be worked out, or maybe just some issues in the case may be agreed upon. And so, in both family law cases and injury law cases, we mediate. Sometimes it is by agreement of the parties, and sometimes it is court ordered. Actually, more courts are including mandatory mediation as a part of the litigation process. And so usually we kind of coordinate a date where the mediation is placed on the calendar. It could take all day. And so I think that's important to keep in mind, that you don't necessarily know how long a mediation may take. So just be prepared that the process may take all day, to maybe have a good faith opportunity to consider all potential issues in an attempt to settle the case potentially. And so nowadays, mediation looks different depending on what type of mediation it is. It could be in person or virtual. So let's first talk about a virtual mediation. If it's virtual, which I would say more and more mediations are done virtual. And if it's virtual, the mediator will send out a link. For our office, we would attach that link to the calendar, and the parties would log in through this particular link. Usually it's Zoom, but sometimes other meeting options are used. The mediator will either do one or two things: bring all the parties together in one meeting room, virtual room, where everybody's on the screen together with the mediator. Usually when everyone's together all at once, the mediator would go through and read the disclosures and rules and the agreement that the parties must sign. Sometimes this agreement is signed before mediation starts, but a lot of mediators like to actually have the document signed during the introductory part. Once the introduction is done, and this is if the mediation starts with everyone in the same room, then the mediator would separate the parties into different virtual rooms. And so, if, like, for example, if you're on Zoom, the mediator will say, okay, plaintiffs, I'm going to go ahead and put you in a different breakout room, and then you'll see a little button pop up on Zoom that gives you an option to go into the breakout room, and then you'll go in the breakout room. And then what the mediator does is goes back and forth between the parties. Now, the way that a mediation starts, virtual or in person, depends on the actual mediator. Sometimes we all come together at once, and after the rules are done, which is what I just talked about, once the mediator goes over mediation, what is it, what's the process, operating in good faith, what the mediator can and cannot do, what's the mediator's role, that the mediator can't be called to testify in trial for the most part, with a few exceptions. Once the mediator goes over all of that, then depending on the mediator's style, one or two things can happen. You can have an opening statement with everyone in the room to hear, or you can break out into different rooms and the opening statements take place separately. I must say, with injury cases, it is very common that the opening statement will be done with all parties together. And then after the opening statements have been made, then at that point, the parties separate into separate rooms, which we call caucus, and then the mediator goes back and forth. In family law cases, however, sometimes the mediator wants all parties together during the opening statement, but a lot of times, because family law can invoke emotion, and it can create a situation where if the statements are put, everybody is together and you hear the opening statements, it could create like a defense where people are less likely to want to negotiate. So usually, what I've seen lately is that most mediators in family law cases will separate the parties during opening statements and then go back and forth to hear both sides. The goal of mediation is to really see if there is an opportunity to settle the case in its entirety, or at least address some issues. Particularly in a family law case, we can address some issues. For an injury case, we would be looking to settle the case in its entirety or not. And so, how to prepare? You have to be prepared to be flexible. If you're at a place where you have an understanding of what you want and there's no way that you would do anything less than the likelihood of settling in mediation is unlikely. If you come into mediation with an open heart and or open mind, and understanding that there are some things that can be changed, or that there are some points that you are willing to release or accept or modify in your stance, then mediation can be very powerful. Coming to mediation in good faith does not mean that you have to walk into the door knowing that you're going to settle. What I do with my clients for all cases is we have a mediation prep meeting, and we walk in knowing what we're willing to accept, what we're not willing to accept, and sometimes it can change the day of, and what are some points that we would definitely need to walk away from, so that we walk in together with a plan on what we're looking for to achieve in mediation. Even if mediation is not successful, because it happens sometimes, it is still a good way to understand the other party's position. Because it may be, and it happens at times, that you don't settle during mediation, but there is rooms to continue negotiating outside of mediation. And so if the case settles during mediation, an agreement is drafted that the parties sign at that time. And if the case doesn't settle, if it's court-ordered mediation, then there's a certificate that you would receive to show that the parties and did in fact mediate as court-ordered, and that certificate would then be filed on record, so the court would have notice that the order to mediate was complied with. And so that is the overall view of mediation within our office. We always have a pre-mediation meeting to address any questions, concerns, or issues. And that's that.